Welcome to Real Estate Radio Live, an informative and engaging podcast discussing everything you need to know about the world of real estate. Your host, Joe Caccera, provides you with insight and guidance on how to buy, sell, finance, and invest in real estate. He also offers real estate tax management strategies, new construction advice, home improvement tips, and much, much more. And now, to guide you around the world of real estate, here's your host and Real Estate Radio Live team leader, Joe Caccera.
Welcome in, Joe Caccera with Real Estate Radio Live, the podcast series. Thank you again for spending the time joining us. And also as we move through the week, before I introduce my guests, let me just give you some reminders. Or if you are in the market for a purchase and you need financing on that purchase or refinance, maybe you just need to restructure a mortgage, or if you just need to visit that opportunity or thought, give me a call. You could always check in, text or call 408-838-9060, or you could email joe@reradiolive.com. Most of you know that the show, for 7 years we did radio, and then we transitioned into podcasting. The focus has been the same. It has not changed. That is to provide you, the consumer, with education and information in and around your real estate, really to help you make wise financial decisions. And who better to have in about wise financial decisions? Linda MacKay. You've probably heard her before on the radio and podcast. She is an attorney with the MacKay Linda Law Offices of Linda MacKay. Welcome back, Linda.
Thank you. I'm glad to be here today.
Good to have you here. 7 biggest mistakes people make with their real estate plan. And this is something that is really, really important. I know we talk about it a lot, and I am guilty of this myself. I'll do full disclosure. I still owe Linda some information. See, I'm gonna. This is actually therapy on the air for me or on the podcast.
This wasn't the 7 biggest mistakes people make.
That's
this
right.
is the 7 biggest mistakes Joe made.
So see, I could live from this, and I could live
plan, right?
So full disclosure. I make my own set of mistakes and still have to fix them. But we're here to help, hopefully guide you, give you some information, and move you along in that process. Well, before we get started, Linda, give listeners a little bit about your background and then your current roles and responsibilities within your law firm right now.
Sure. So I have been practicing estate planning in Santa Clara County for 20 years. This is my 20th year in practice now. Graduated from Santa Clara Law School many moons ago. Started with a small firm in Saratoga, and then about 10, 12 years ago went into private practice. And I have a master's in tax as well, so my practice is focused on estate planning with kind of a heavy emphasis on taxation issues and the taxation items that come up when somebody's thinking about transitioning, passing property, setting up their estate plan.
And is that because those two make so much sense? They go hand in hand together, really?
They do. There's always going to be a tax component when you're thinking about passing assets and property from one person to another, whether it's a passing during your lifetime or at death. We need to think about capital gains, estate tax, property tax reassessments, and all of that.
Very good. All right, so let's get started and talk a little bit about the good old will versus the trust. My guess is you say make sure you have something, but maybe give the listeners an idea of the two differences and maybe the people that are just fine having a will, let's say.
Sure.
And then what would trigger someone to say, you know what, I really should entertain the thought of a trust versus a will?
Right. Well, and I think that, one of the biggest problems with somebody's estate plan is that they don't have one. And they haven't put anything together yet.
Right.
If you have no will, no trust, no documentation whatsoever, then you are considered intestate. And what happens in Santa Clara County or any county in California is your estate will be rallied into the probate court, and the probate court is going to take care of the transition of your assets, and they're going to go to the statutes to determine where your assets will go. You don't get a voice in that. And so that's problematic. It's going to take a long time to get through that probate court. There's going to be tremendous amount of fees, and what you end up with may not be what you had in mind. It might not end up going to the people or in the manner in which you would have prescribed if you had taken the time to put your thoughts down on paper.
Yeah.
So 2 ways you can handle that. You can put together a will. And a will is it simply a contract that you'd put together that says, in the event of my death, then I want my assets to be distributed as follows.
Okay.
And you put down your terms and conditions. The problem with the will mostly is twofold. The first is it still needs to go to probate court. That
so
will,
no matter what.
Yeah, that will is the same as if you're intestate. You still end up in probate court, and the probate court judge is still going to oversee the process. The difference between that and not having anything is now that court judge has your will that dictates who you wanted to have what. So at least he has some guidance in the matter, and perhaps he'll follow those instructions as opposed to just going to the state statutes to determine who gets what. The other issue is it's only if you've died. What if you haven't died? What if you're incapacitated? You're in a coma. You've had a stroke. Somebody needs access to your money to be able to pay for your care, to pay your property taxes. They don't have it if you just have a will put together.
Right.
So with a living trust, you've put together this entity, this thing that can hold all of your assets and all of your property. You put down the rules and conditions of who's going to manage it in the event of your death or incapacity. You have named somebody who can step in your shoes and take care of those assets. And we don't have to go to probate court to administer it. We administer it privately with the trustee.
Okay, very good. That's a good point. That would you say that I'm guessing as we're talking through this, listening to, let's say a person had no property at all, whatever reason, and it's very simple. Maybe they had a few odds and ends they were going to give it to their children or grandchildren or whatever. Would you say a trust is still important because of the things you just described, or is it more around your assets and whatever you are leaving or whatever could be at risk, I guess?
Right. So California has a small estate limit.
Okay.
And that says if the total value of the estate you're passing falls below a certain amount, then the rules are a little bit different for you. You don't need to come to probate court. You could administer it without a court proceeding. It's $150,000. Okay. So it's really low.
Really low.
And so anybody who owns real estate in California, they're probably automatically over that, right? Just with their good faith deposit, they're over that, right? So there are occasionally some folks that come into my office that say, look, I'm living on my Social Security. I don't own a home. I'm in a retirement community, and, I get my Social Security. Maybe I have a small bank account or something like that. They don't perhaps need a trust. What they would need is a will. And then in order to account for the incapacity issue, they need a really good power of attorney.
I see.
And so I would never recommend just a standalone will. If you're going to go the route of having a will, make sure you have a good power of attorney in case you're ever incapacitated.
Got it. So talk a little bit about the, you talk about the trust not properly being funded. What do you mean by that? Talk about that a little bit.
So just creating a trust and putting your thoughts on paper isn't going to be good enough to get you out of probate.
Got it.
So in order for an asset to not have to pass through the probate court process, it needs to be owned by the trust. So the title to your bank account, the title to your home needs to read the registered owner as the living trust, not you as an individual. And what I find is when people are initially setting up the trust, they're working with an attorney who's guiding them through the process, and we make sure every account, every asset, every piece of real estate, the timeshare in Maui, that it's all in the trust, right? We get all of those things into the trust, and they leave, and everything's perfect. And then passage of time happens, and they sell the timeshare in Maui, and they buy one in Oahu, and they didn't buy it in the name of the trust. Or they change properties, or they buy an investment property, and through the passage of time, their assets start to come out of the trust just because they're not keeping up on that funding. Okay. Anything that's outside the trust is not going to be protected from that probate process.
Okay.
And so they need to make sure that they're continually looking at those assets. I usually tell people tax time. At tax time, you're getting all of your statements in the mail. You're getting all those 1099s. Look at the title. Does it have the name of your trust on it?
So you're saying property, let's say bank accounts, investment accounts. So if you have an investment account with Schwab and maybe you have a Wells Fargo account, everything should also be listed in the name of the trust.
There's one exception, and that would be a qualified retirement plan.
Oh, okay.
Because there's income tax considerations to that. There's deferred income tax, and so that still needs to be tied to the individual, so we have different advice for those. Okay. But everything else that you had listed, right, all of your investment accounts, the checking, the savings, the credit unions, your coin collections. They all need to be in the name of the trust.
What if you have a separate corporation, partnership, things like that? That I know that also needs to be listed within the trust. But if it's a separate name or corporation, that's different, I'm guessing, right? I mean,
a little bit. It's we would consider that a nested asset, where if it's a corporation, you have a stock certificate that's issued.
Right.
And who is that stock certificate issued to? Is it issued to Bob Smith? I want it to be issued to Bob Smith as trustee of Bob Smith Trust dated 2017.
Okay.
And so then the assets would be owned by the company, and the ownership in that company is owned by the living trust.
Got it. And the when you say the date, too, I notice that's on a lot of the trusts. Could that date, is that the date, obviously, they created the trust? Now,
correct.
Can that date change on those trusts, depending, or is it always the date they originated it?
It's always the date that you originated it. If you want to change the date for some reason, you would cancel, revoke that trust instrument, and you'd start over with a new trust instrument. Right.
Okay, very good. All right, we're going to take a break in just a minute. Before we do that, though, for someone that wants to get in touch with you, Linda, maybe they want to know more about the advice, the taxes, really everything you do, phone number and a website?
Sure, the phone number is 408-379-9600. And the website is www.ljmlegal.com. And we're located in San Jose, near the corner of Winchester and Hamilton.
And her crew does a great job. You have a good staff. So we were just talking before we came onto the podcast here. Does it fluctuate as busy? I mean, if someone wants to contact you, does it typically happen where people near tax time all of a sudden they think about that, or certain times of their life? It could be when they have children. Things trigger.
I think the things that get people to call my office usually is the death of a parent, and they see what that process was like, and maybe mom or dad had a trust, or maybe they didn't, and they see either how easy or how difficult that was for them to administer, or the birth of one of their own children. That usually gets folks to come in. And then I've shot myself in the foot a little bit by always advising my clients to review their estate right around tax time. So right around April and May, I get a flood of calls. That's my own making.
When you're busy, too.
Yeah, that's my own doing.
All right, this is Joe Kuchera again with the Real Estate Radio Live, the podcast series. We are sitting here today talking with Linda MacKay of the Linda MacKay Law Offices. I'll be back with you to continue in just a minute.
For more information on today's program, visit RERadiolive.com. That's RERadiolive.com.
Hi, this is Joe Kuchera, host of Real Estate Radio Live and Bay Area Mortgage Planner. In addition to being your home financing expert, please remember you could always contact me for other trusted advisors such as realtors, financial planners, and CPAs. Please feel free to contact me at 408-838-9060. That's 408-838-9060, or email joe at RERadiolive.com, or visit my website at RERadiolive.com for more details.
Welcome back to Real Estate Radio Live. For more information on today's topic or guests, just visit RERadiolive.com. That's RERadiolive.com. Again, your host for today's edition of Real Estate Radio Live, Joe Kuchera.
Welcome back in. Joe Kuchera with Real Estate Radio Live, the podcast series. As we continue the show today, I am joined in studio by Linda MacKay. She is of the law offices of Linda MacKay, specializing in trusts and also, what would you call it, trusts and also taxes? Or how do you marry those together? I guess they both go together. So
they do. Trust and tax.
They do hand in hand. And we're talking about the importance and really some of the examples of the difference we did in the first segment about the will versus a trust and why it's so important and the naming of it. So let's talk a little bit now about the periodic review. Just before we ended the first segment, you chatted a little bit about that, how you get inundated sometimes.
Right.
But talk about some of the reasons a person, or how important it is to do the review.
Right. Like, a lot of people put together their trust and they kind of set it up on the shelf and forget about it for decades. And it's a living, breathing document that you need to maintain.
Mm-hmm.
And you need to periodically get it down, dust it off, and have a look and make sure, have I kept up on my funding? Mm-hmm. Did we buy 2 or 3 more properties or open new accounts since the creation of this trust? And did we properly take title to them in the name of the trust? Have our kids changed, right? Meaning maybe you have more kids, or maybe your kids were 8 and 10 when you first set it up, and they're in their 30s now. Mm-hmm. And you have Aunt Sally listed as the trustee, but she's 107, and so she's not a good choice anymore. And so these types of things happen. I get clients all the time who come in and somebody's passed away, and we look at the trustee list, and there's 4 or 5 of them, and more than half of them are already dead. Because they didn't get it out and have a look and update it and review it. There's also changes in the law that happen that you need to make sure that your trust has kept up with those legal changes. And, is the language in your trust still good law, and is it still the best law for you? In 2011, there was a big change in the estate and gift tax code section, and dealing with how assets pass between spouses and the maximum taxation that I can get for an estate tax exemption between spouses. And I have a lot of clients that say, oh, well, we're okay because, the new tax law, so we're all set. And, no, darling, your trust was dated in 2004 or 1994, and it doesn't have that appropriate language in there. And so just because the law has changed and there might be this new razzle-dazzle newfangled way of doing something doesn't mean that your trust incorporates that or allows you to do it.
Very good. One of the things that I didn't intend to talk about, but you're quick on your feet. I was thinking with all the changes in technology, every day we hear about the evolution of technology and retail stores closing down and no more bookstores and everybody's buying stuff online. And in your world, it's probably the LegalZoom, right? The people that go to different things. Talk a little bit about, is technology or any of this evolution changing what you do? My guess is no matter what you do in the forms and documents, you still better have some really good advice, because if you get into trouble or something does happen, God forsake, with you'd better have it set up correctly, and wording has a lot to do with it. Talk a little bit about, the people that choose that direction and what they, is it a good idea? Is it a bad idea? Talk a little bit about that.
I get a lot of people that call up and say, all right, I put together a trust. Yeah. I went online. I went to LegalZoom or Trusts R Us, and I did one. I'm going to bring it into you. You're going to look it over and tell me if I did it right. And it's only a small piece of it is actually about the document. A lot of it has to do with getting advice from somebody who knows all the terms and conditions that are available and all the pitfalls that you could come into, and be able to apply that to your situation and tell you what you need. Right. And so if you're not having somebody kind of guide you through that, you don't know if the terms and conditions that you're selecting to go into your trust are appropriate for you or not. I get a lot of people who come in and they've gotten their advice from their neighbor or from the Internet. The Internet is an amazing place, full of information, right? But is it applicable to you? I had somebody come in a couple months ago, just livid, because he was pretty sure his guy had done his tax return wrong, and he wanted me to review it. Because his neighbor sold his house a year earlier, and he didn't pay any tax. And so this guy sold his house, and he owed a boatload of money in tax. And, well, that can't be right. Because his neighbor told him, well, when you sell your house, you get $500,000 you don't have to pay tax on, right? Well, this wasn't this guy's primary residence, and so he didn't qualify for that. Yeah. But, he just assumed, oh, well, great, that's the way it works. And so you need to make sure what is your situation and what are the facts around, your financial and personal world, and how does it relate to you, and what terms are appropriate for you. And the Internet doesn't know you enough and doesn't know the right questions to ask you to be able to put together a good document.
I always look at that as more as just as forms and templates. I would think that maybe simple things, but something that's so involved as a trust. I mean, in many cases, let's face it, a trust, you have your livelihood, you have your investments, you have your children, you have everything, and to leave it to the chance of a template, something that's, I would think that someone would be wise to hire someone like you and double check. So let's just say someone started that way. They thought it was a good idea. They went online and they did it. So could they still come to you and say, hey, I'm not comfortable with this. Can you help me redo it? Would you then, Linda, say this is great, but you have to understand that that's another template for another company or organization. I have to create my own. How does that work?
Yeah, I'm definitely going to create my own set of documents. I'm not just going to amend or tweak something, even if it was done with another attorney down the street whose reputation is stellar and who I know, did a good job. Still, if it's going to be a document that comes out of my office, it's going to be my work, right? If they'd already created that trust, maybe with LegalZoom or I had a whole family that came to me. It was mom, dad, grandma, grandpa, the kids. Dad did their trust. He wrote it himself, and he did all the research, and he had this. And so they all had these trusts, and they were already in effect, and they had already titled their assets and their houses into these trusts. Mm-hmm. And so if I revoke those and start it over, they're going to have to retitle everything. Mm. So what I did was what we consider a complete restatement. I kept the name and date the same, but I wrapped it up in all terms, all brand new terms as a new document from my office. And so that was a good solution, for that couple. Very
good. What we talked a little bit about preparing the documents, kind of what we talked about now, how important it is. But updates, we talked a little bit about updates. On the medical stuff, I guess I want to touch on a little bit of that. The importance of that, of course, if someone becomes incapacitated, you touched on that a little bit earlier. Does that get challenging at times, or is that really just people try to avoid that, or is that something that you address in every single one? I mean, it's probably something people say, well, I don't want to have to talk about it or deal with it. But
right. It's a difficult topic. Nobody wants to come in and spend an hour talking to me about all the gruesome ways in which they might die. Mm-hmm. It's no fun. I always ask about a healthcare directive as part of my comprehensive package, right? I need to think about you as a financial being, and that's kind of the meat of what we're doing in my office. Right. But you're a parent also, so I need to think about your kids, and are we going to, protect your kids? Are they minors? Who's going to be the guardian? I need to think about you as a person, right? Who's going to care for you and make choices for you if you're incapacitated? And so that's where a healthcare directive comes in. Sometimes people come in and they already have one done through their hospital or their primary care doctor, and so that's fine. We'll just incorporate that existing one if it's still current and reflects their wishes. If they haven't done one yet, then I would strongly encourage them to do one and to set up that healthcare directive. And it's not uncommon. Every week I have somebody who says, well, these decisions are too hard. The decisions about, should I be kept on life support or should you terminate? Do I want to be cremated or buried? Do I want to donate my organs? These decisions are too hard for me to think about these things, and so I'm not ready yet. And what I try to impress upon them is, if this decision is hard right now for you to make for yourself, imagine how hard it's going to be for your spouse or your child to come in and make these decisions for you. And so are you doing, a favor to them by putting your thoughts on paper? And so at least it relieves a little bit of the burden for them to say, this is exactly what Mom would have wanted. And I can go ahead and, it's still no fun. Yeah. It still stinks to be in that position of having to make that choice.
That's a good analogy, though. I think that's to remind someone how difficult it would be.
Right. If you can't decide for yourself, how is little Johnny going to decide for you? Johnny's 20 years old. This is a terrible situation for him. And now, Mom would never talk about it. And so he doesn't know what she wants. Yeah. He doesn't know. He can't have that peace in his heart that he's doing the right thing, that he's doing what Mom would have wanted. And sometimes that's, a great relief of that burden for that person.
We have a couple minutes left. One of the things, I think I may have brought up with you before, and the only reason why is I had a friend that went through this, and I thought, wow, I never thought about that. And he was, unfortunately, diagnosed with cancer, came on really quickly. Things in his personal relationships were kind of cloudy. He was divorced but not really divorced and had a girlfriend and all these types of things. I remember he had one of his best friends come in like when he knew he was dying, right, and change his trust or whatever.
Right.
I mean, I may have brought this up to you. I was like, oh, my God, I never thought about something like that.
Right.
Well, you know what? Now that I'm dying, I'm not sure that I want this going to this person. Do you ever run into something like that?
I do, and, it comes down to having to really assess the capacity of that person. Sometimes there's a little bit of undue influence going on, or maybe I don't feel well, I'm sick, and so my will's not as high, so I'll just sign whatever just to get you to go away. Or sometimes as people get closer to the end of their life, they start to really, now it's real. Before, when they did it 20 years ago, it was kind of, maybe I'll give it to my mom and my sister, and now this is really happening. And so they really start to think about it, and maybe sometimes their mind changes. And so that's really up to the attorney and the notary that's doing it to make sure that this person has legal capacity. Sometimes we'll go to doctors and get doctors, a certification of capacity that this person still is in there, has the wherewithal to make these choices.
Wow, you got a tough job. But you love it. You love it.
It's not tough, it's fantastic.
All right, unfortunately, running out of time. Linda, thank you so much. Always informative, a lot of great information, and we'll have you back in a couple of months.
Terrific. Thank you. I look forward to it.
Thanks again for tuning in today. Joe Kuchera with Real Estate Radio Live, the podcast series. As always, if you need any more information, you can go to RERadiolive.com. Take care.
You've been listening to Real Estate Radio Live. For more information on today's program, visit RERadiolive.com. That's RERadiolive.com. Subscribe to our podcast. Discover more at RERadiolive.com.